For years, we've been sold this idea, right? This popular myth that the rise of e-commerce and the internet has just completely erased international borders, giving us this one big, happy, seamless global village. But as we're going to see today, that utopian vision of a totally borderless world, well, it's clashing pretty heavily with reality.
So, I want you to ask yourself right now, did the internet actually erase borders? Or did it just change what those borders look like? Today, we're unpacking a massive central conflict. We've got completely borderless technology on one side, think social media apps and global ride-sharing platforms, colliding head-on with the very strict, deeply rooted local government regulations that still rule our physical world.
Here's our quick agenda for today. We'll hit 1. The borderless illusion. 2. Navigating global business rules. 3. The social media blackout. 4. China's digital wall. 5. Disrupting regulated markets. And finally, 6. The global manager's playbook.
Okay, Section 1, the borderless illusion, or the myth of a global utopia. Let's lay down a quick foundation with this definition from the source material. E-commerce is basically commercial transactions requiring the transfer of information using modern technologies across the internet. I mean, it sounds completely borderless, doesn't it? It implies you can buy, sell, and communicate with literally zero barriers of time or distance. But here's the kicker. While the technology itself is boundless, governments are rapidly building new policies and digital walls to protect their local entrepreneurs, their consumers, and their cultural sovereignty. And understanding this is absolutely crucial, because ignoring these digital walls, well, it can cost a business the whole shebang.
Moving on to Section 2. Navigating global business rules, looking at the day-to-day mechanics of global work.
Let's look at something super common, like a non-compete clause. In the US, an employer can usually enforce one of these without paying any extra compensation to the restricted former employee. It's standard practice. But jump over to Europe, specifically Spain and the Netherlands, and the rules completely flip. Over there, these clauses are generally only valid if the employer actually pays adequate compensation to the employee when they're terminated. So you literally cannot just copy-paste an American contract in Europe and expect it to hold up in court.
And when we talk about digital privacy, the frameworks are just wildly different from place to place. Take the UK, for example. Under their lawful business practice regulations, there are 5 very specific exceptions where employers can actually monitor your emails without getting your express consent. They can do it to determine facts or compliance, prevent or detect crimes, investigate unauthorized use of their systems, secure the system's operation, or just to check if a communication is actually business-related. It's a highly precise legal framework, and it's the kind of thing a global manager has to navigate every single day.
Now, this clash extends right into global business ethics too. Take insider trading. In the US, if a corporate director stays silent and fails to disclose material inside information when making a trade, that is considered fraud. Period. It's a massive criminal and civil infraction. But remarkably, in Japan, silence isn't necessarily fraud. Unless the director is actively concealing the info, or if they were directly asked about it, just remaining silent about inside information when trading isn't a criminal wrong there. It's a truly stark, fascinating contrast in fundamental legal philosophy.
If we take a step back and look at this timeline, you can see exactly how countries have steadily been building these digital legal frameworks over the last 20 years. Back in 1998, the UK passes the Data Protection Act to regulate employee monitoring. Then in 2001, Argentina amends its civil code to legalize digital signatures. The very next year, 2002, Russia expands trademark protections to internet domain names. Fast forward to 2015, and a German court actively bans the ride-sharing service Uberpop. These aren't just isolated blips, they really show the ongoing global construction of digital borders.
All right, Section 3, the social media blackout, dealing with state censorship around the globe.
Looking objectively at the source material, governments cite some very distinct motives for pulling the plug on social media access. For example, back in 2014, Turkey temporarily banned Twitter after a recording leaked on the platform that revealed alleged government corruption. Pakistan previously blocked YouTube when the platform refused to take down videos that were deemed insensitive to Muslim religious beliefs. And in Nigeria, local media and digital channels were historically influenced to suppress news coverage of nonviolent separatist protests. So, the mechanisms and the stated reasons vary wildly, but the end result? The digital border comes slamming down.
Which brings us to Section 4, China's digital wall, looking at the Great Firewall and local giants.
Now, the crucial point here isn't just that Western platforms are blocked in China. It's about the massive vacuum that creates.
Banning Western tech like Facebook, YouTube, and Twitter basically allowed huge domestic Chinese platforms to step right in and flourish. Renren and WeChat took Facebook's spot, Youtudo became the Chinese equivalent of YouTube, Sina Weibo took over the Twitter space. State censorship effectively acted as this incredible, massive incubator for local tech giants.
Just take a look at this staggering number, 846 million. That represents the user base of WeChat. And we're not just talking about a simple messaging app here. WeChat completely dominates daily life in China. People use it to talk to friends, watch videos, pay their bills, and even run entire businesses, all inside this one single ecosystem. The sheer scale of this domestic dominance means foreign platforms aren't just facing legal red tape anymore, they're up against an absolute market Goliath.
And if the legal and competitive barriers weren't enough, get this surprising linguistic hurdle. The phonetic translation of the word Facebook in Chinese is Facebook, which literally translates to have to die or must die. I mean, wow. It's just another fascinating, kind of wild addition to the long list of reasons why re-entering the Chinese market is a massive uphill battle for Western platforms.
Next up, Section 5, Disrupting Regulated Markets, or what happens when borderless tech hits local laws.
Let's look at the huge legal battle surrounding Uberpop in Germany. This is just a fascinating case study in competing priorities. On one hand, you have Uber's stance. They argue that their algorithm is simply more efficient, providing a cheaper, better service that's a massive win for consumers. But on the flip side, the German Taxi Association argues that Uber's model completely bypasses necessary consumer protection laws and that it creates unfair competition by just flagrantly ignoring the rules everyone else has to follow.
To really understand the Taxi Association's argument here, we have to look at exactly what Uberpop drivers were bypassing. In Germany, getting a legally mandated taxi license is no joke. A driver has to prove they're physically healthy, demonstrate this extensive knowledge of the city's streets, hold highly specific commercial car insurance, and regularly prove their vehicle isn't damaged. These are incredibly strict requirements designed for basic consumer safety. Now, by avoiding all those licensing expenses, sure, Uberpop could offer cheaper rides, but the German courts essentially ruled that bypassing the law is not an acceptable business strategy.
And the consequences for ignoring those local laws, they are severe. Take a look at this. A massive €800,000 fine slapped on Uber in France for operating services that didn't align with French law. It really proves that having a highly disruptive, super popular business model doesn't just grant you a free pass from local jurisprudence. Testing those boundaries can hit your wallet incredibly hard.
All right, bringing us to Section 6, the Global Manager's Playbook, with some key takeaways for the 21st century.
If you take absolutely nothing else away from this explainer, please keep these 4 essential steps in your back pocket before trying to cross digital borders. Step 1. Research local regulations thoroughly. Never, ever assume your home country's laws apply. Step 2. Align your business models with local cultural and ethical expectations. Remember those wild differences we saw with privacy and insider trading? Step 3. Anticipate serious pushback from incumbent competitors because local associations are for sure going to fight back. And Step 4. Be ready to adapt your technology to stay legally compliant. Doing all this homework up front is going to save you money, time, and your brand's reputation.
I actually want to read this quote directly from the source material because it really hits the nail on the head regarding our core thesis today. It says, "It is critically important for modern researchers and practitioners alike to closely examine and explore the legal aspects of contemporary e-commerce prior to doing business across cultures. Basically, a sleek app or a lightning-fast website does not replace the absolute necessity of deep cross-cultural legal understanding."
So that brings us to the end of our explainer. But before we wrap up, I want to leave you with one final thought to chew on. As technology continues to accelerate at breakneck speed, will conventional legal barriers eventually bend and loosen up to allow for more seamless global growth? Or are we entering an era where national digital borders will only continue to rise, basically fragmenting the internet into heavily guarded regional silos? It's a huge, profound question that every single modern consumer and business leader needs to be thinking about.